My name is Brian Panish, and I'm a partner in the law firm of Panish, Shea, Boyle, and Ravipudi. We practice in California and Nevada.
You know, Brian, always good to have you here. I want to take this opportunity to dive into some specific wisdom, right? You know, you've been practicing 40 years, and there's a lot of wisdom that you've gathered. So I want to dive into a few key parts of trial practice: voir dire, opening, direct, cross, and closing. Right? A lot of people feel like they understand voir dire. What is a trial lawyer's goal? What are you trying to do in voir dire, and how do you accomplish that?
My goal in voir dire is to find the jurors that can sink my case. It's a deselection process. There are certain issues that I'm looking into that I know could be hurtful to my case, and if there's jurors that have personal experience in that, or just the background, experience, and mindset, and the DNA that's not good for my case, I want to find them. And I want to find the leaders of those type of people to make sure that you don't have one person that takes over the whole jury.
Right. And you know, I think a lot of people, they go about it in different things. You know, somebody yesterday was talking about tribe building. For example, you're trying to win people on your side. You're trying to get this person, and you know you want to keep this person. Is that something that you ever are trying to do?
You know, indirectly, I mean, I'm not building the tribes, but I look at people, are they followers? Are they leaders? How will they mesh? I watch the jurors when they're not in the courtroom, when they're out in the hallway. Who's talking to whom? Who's leading the conversation? Who's sitting off by themselves? Tells you a lot about jurors.
So let's move on to opening, right? You know, a lot of time, I remember in law school, look, you can't argue in your opening, right? And you know, why is that important? And what should a lawyer be trying to accomplish in their opening statement? You got a lot of attorneys, and I'm sure they ask you, you know, what am I doing, right? How are you teaching opening statements?
Well, I want to come out strong in my opening statement. I never want it to be more than an hour. I think the jury only has so long they can listen and pay attention. It's important, I think, to come out strong, to use most of your strong evidence in your opening statement. Once the jury's picked and the opening's given, I think the case is pretty much decided. So I like to be able to look right in the juror's eyes, talk to them, tell the story about your case. And you always want to be telling a story and what your client's life was like, how they got here, what the defendants did, and how you go about compensating them.
You know, sometimes people talk about making sure that you are bringing out some of the defense's strong points in your opening so that you're kind of stealing the sting, right? You're taking away the power of that.
So what I do in my opening is I usually say, go through my part, and then I said, so I've told you what we're going to prove. Now let me tell you what the defendant says they're going to prove, and I raise each one of their defenses. I get to frame it how I would decide or how I would call it, and then I knock down each one as we go. But you know, if you prepared your case, you know what they're going to say. You need to prepare and proactively address what they're saying and knock it down before they get a chance to talk about it.
So let's jump into the meat of the trial, right? You got witnesses, you have evidence. Right. What are you looking to accomplish in direct, and how are you lining up your witnesses so that you're continuing to buttress the things you've already laid out?
I mean, the way I look at it, it's like a game, and you're scoring points. Every time you put on a good witness, you're scoring. Every time you put on a bad witness, you give them an opportunity to score points. So I want to start in the beginning of the trial, putting on witnesses, sometimes the defendant, that are not really going to be able to help them. So a lot of witnesses, I'm start scoring points, building credibility, getting ready for maybe some witnesses that aren't as strong, and really preparing for the cross. The direct exam, I like to tell it in a story way, is much harder than cross-examination because jurors don't want to hear lawyers leading the witness. And I see it all the time, and I get the defense on that all the time for leading, because they don't know how to ask non-leading questions. And the jury wants to hear your client speaking, not you. And that takes a lot of time spent with your client, a lot of preparation, and practice. You don't want to look rehearsed, but you want the client to be able to explain what they've been going through. It's also important to have surrounding witnesses and not have the plaintiff up there whining or complaining, and let other people do that for them.
What are some of the challenges that you face, or maybe on a regular basis, or maybe some of the biggest challenges you face in direct examination, right?
Well, I'll tell you, one of the biggest ones is interpreters. Represent, in California, is a huge Hispanic population. Many of our clients are Hispanic. So trying to convey to a juror something through an interpreter is difficult. So you have to work with the interpreters. They have to be familiar with the client. You want to get a good interpreter. And I think that is a very difficult thing.
Yeah, and I would imagine even some of your own witnesses, I'm sure you faced, your own witnesses, maybe they say something that you're like, look, that wasn't in the playbook.
No, they're not professional witnesses. It happens
Sure, right.
all the time. So you need to try to prepare against it, but the client's not going to be perfect usually. There's going to be some issues.
How are you teaching your attorneys to deal with things going off the rails in the middle of a direct examination?
I mean, what we're teaching them is to just get back on message. Don't be affected by it. Don't react emotionally, because the jurors are looking at you and they're saying, how's the lawyer look? And if the client gives a bad answer and you're like, oh my gosh, that's bad. But if it's a bad answer and you just keep rolling along like it's no big deal, they're going, well, it must not be a big deal. He doesn't seem to be too worried about it.
All right. Let's jump over to cross. And, cross is a very different beast. How do you approach cross-examination? And then we'll talk specifically about crossing an expert.
So, first of all, when I'm preparing for a trial, the first thing I do is prepare all the cross-examinations before the direct. And I do that because I want to be able to bring out our theory of the case through cross-examination, hopefully in a narrative form. But also, I like to bring out, in cross-examination, knocking down favorable points that the defense thinks they have. And then here's an example. Let's say you have an eyewitness to a traffic collision who says the light was red, which would be adverse to your client. But they saw your client and how injured they were and how they were taken to the hospital. So I would start that out with, you were at the scene, you saw him, how was he doing? Oh, terrible. What did he look like? Get that damage testimony that's favorable, and then flip to discrediting him, taking a little bit of the shine off it. You're not going to kill every witness, even though you think that. It's not going to happen. Cross-examination takes preparation and discipline, big time.
And it makes total sense to, there's the whole primacy thing, right? If you start off with that, rather than ending with it, right? Oh yeah, but the light was red, and that's the last thing the juror hears from that witness, right? It's better to start off with that, get that out of the way, and then finish with things that are stronger. It sounds like.
Well, you want to start off strong and you want to finish strong. You don't want your last question to be some dud, and then like, oh geez, now what do I do? Okay, no more questions. You want to hit them hard, boom, done. I'm done with this guy or this person, and the jury goes, oh, we can't believe that person.
Now let's talk about experts. Right, I had a lot of attorneys that are like, I love cross-examining an expert witness. How do you look at defense experts defense experts, and how do you approach it?
Generally speaking, I don't try to cross-examine a defense expert on their specialty, because I think you're getting into their expertise. If they're a good, smart doctor, engineer, you're going to have a problem. So I would probably first, depending, if you have them dead on the case, okay. But usually you're not going to have that. So you have to use collateral attack. You have to go for bias with the money. And I always ask this question, sir, you're not testifying, or ma'am, you're not testifying here today as an independent witness, are you? They go, smart ones will say no. Some will say, well, yes, I am. Then you get right into the perfect lead into the money. Oh, are you getting paid? Oh, they're paying you. How much are they paying you? How many hours? All that. So you would agree if they paid you $100,000 that you're probably not an independent witness, wouldn't you? So right away, you've taken that away from them. And then you might get how many times they testified, always for the defense, all this collateral stuff, and maybe you'd hit their opinion on something that they'll agree to. If you have a deposition, they've already said it, you got to be careful with experts because you can get burned.
Yeah, and you know, with an expert, getting burned by an expert can be really bad, right? Because this is somebody else, like the jurors, like, look, this guy's a doctor, and he just burned the plaintiff.
And the lawyer looks bad. And then you're trying to scuttle around and try to rehabilitate yourself. And I think that's where the discipline comes in. A lot of lawyers are doing well on the cross, and then they ask an open-ended question, like, why would you say that, doctor? And then bam, everything's gone up in smoke. So you got to go carefully, but you have to keep your discipline. Because some of these experts will try to move you into other areas where they feel more comfortable, and you got to stay back on your message.
All right, so let's go into closing. You've gone through, you know, the case in chief. You're closing this thing out. Whether or not it's gone the way that you want it to go, and perhaps, obviously, you know, you approach it differently depending on how the beginning parts of trial have gone. But what's your primary goal in closing, and then we can talk about each scenario.
My primary goal in closing is to arm or equip my jurors that are with me with the arguments and evidence to gather the other jurors and bring them along. And what I say is, you know, this isn't a final argument, because if it was the final argument, I would yell and you would yell back. What this is a reasoning process. As they say in the book of Isaiah, come let us reason together. And I'm here to reason with you, to help you, so when you reason with these other jurors, you can come to a fair and just verdict.
There must be nothing like having empowered a juror like that, where they can go in and they understand the reasoning, and they can go in and convince other people because they put the pieces together. Just a quick thing during the trial. What sort of attention are you paying to the jury?
I'm watching the jurors during trial, but you don't want to act like you're staring at them all the time. So I'm looking, you know, from the side of my face, looking, having other people watch them. But then again, anyone that tells you they can read the jury, they can't. There's no way. It is so unpredictable, so hard to tell. You know, you have the feeling, but you don't know for sure.
Right. Now, I'm sure you have some stories where you've gotten to closing and you felt like it didn't go the way that you wanted. But how do you approach that, right? No, I mean, come on, this guy's got tons of trial experience. Every trial can't have gone the exact way that he.
Well, I think how you believe is how the jurors are going to believe. And when you're arguing that case, and if you're hesitating and you're not really confident and you don't really believe it, they're going to see it. So you have to have that passion and perseverance in your argument no matter what. No matter how bad the trial has gone, you need to shake it off and get in there and do your best and let the jurors know that you really believe this. And if you've been building up credibility and you've been a nice person and you've been making your points, you always have a chance to win if they like the client.
You know, you've been at this for you know, my whole lifetime. Right, you know, why is that? Right, you could say, all right, I'm done. What is it about the work that you're doing that's got you still doing it?
Well, the most important thing to me, and the thing that I love the most besides the trials, is the clients and the client stories. And they come from all walks of life. I mean, I've represented famous celebrities to people that were homeless, and all in between, all nationalities, everything. And I love talking to the clients and hearing their stories and trying to make a difference in their life. And you can do that. And in our business, we're able to affect people, not thousands of people, but I think we've been able to affect the lives of a lot of people, made their lives a lot better when they've been facing, you know, unbearable, difficult, catastrophic situations.
You know, one thing that we've also talked about here is the ability to get corporations to change the things that they've done. And I know you've won cases like this. Maybe what's that like?
Well, it's really important for us, if we can, to get some type of non-monetary concessions as part of the settlement. Whether I had a case where the Child Protective Services didn't have this system where they could match records from different people. So they've promised to enact that, or whether they're going to recall a product, or whether they're going to provide additional warnings. And I think that is very satisfying to lawyers to know that you've done a change. It's not about the money. I mean, of course, they always say it's always about the money when they say it isn't, but there's a lot more you can do other than money.
Yeah, because ultimately by doing that, all the people that may have been affected by that, bad policy, this pattern and practice of wrongdoing or recklessness, you're ending that. So you're preventing ultimately and helping the community.
I mean, and that's kind of the product liability, that I first started practicing, was to try to get the unsafe products off the market. And lawyers have been very successful, if you go through history, and done many things that have made a change in society. There never were the seat belts, the crashworthiness things, the airbags. All these improvements are because they're not trying to make it better. They're worried that they're going to have to pay money. And that's the bottom line for these corporations.
You're here at PSBR, and I peeked in yesterday, and you and Mr. Morelli were up there doing your thing, and I'm watching, and I'm like, man, you're into it, and it seems like a source of some enthusiasm and joy for you. How much are you enjoying teaching as well as practicing?
I really like to share. I was taught, I learned from other lawyers, but you have to go out there and want to learn. And I wanted to learn. I'm still learning all the time. I'm still practicing. I'm still taking courses. I'm still doing, because I'm super competitive. And in this business, if you're not doing anything to get better, people are going to pass you up. Every day you have to do something to better yourself, make you a better lawyer, better person. And each and every day, you can't rest on your laurels.
Why is it good? Why is it important, right, for the plaintiff's bar to get better? Right, there's a lot of, we got footage of people taking meticulous notes while you were up there. People locked in listening. Why is it important for plaintiffs' lawyers as a community to get better?
Well, because I think the sharing and the training makes everybody better. Rises up awards for people, different injury type cases. And when everyone's better, you're going to keep them more in check, the corporations, when there's more lawyers that are willing to take on the risk in these cases. And plaintiff lawyers, I like to say, most lawyers get paid per hour. Plaintiff lawyers get paid perhaps. We only get paid when we win.
All right. Last thing, what do you have still left to do? Right? Is it a case? Look, dude, you just passed. Brian Panish just passed the Nevada bar. Okay, right? 40 years in, and he passed the Nevada bar.
You know what? Because every day you got to do something to get better, and you got to challenge yourself. And if you don't challenge yourself, you're not going to get better, and you're not going to do a good job for your clients.
Last thing, this being a Titans of Trial, this is really, Dan and I agree that the Titans of Trial is not just about people that have won a bunch of verdicts. It's also about people that give back, right? In some parting wisdom here, right? What should young lawyers or lawyers that are looking to be better, what's some basic wisdom that lawyers tend to screw up that they need to know and understand?
Well, number one, don't get too full of yourself. You win a few cases. Number two, what we do is hard, and people in life have choices. You can be bad, it's easy. You can be good. Now, some talent, if you have talent, that'll make you good. But to be excellent or to be elite, it takes a lot more. It takes passion, it takes perseverance, and it means that you have to do tougher, better. You do hard, better. And that's one of our slogans in our firm. We do hard, better. Yeah, it's hard, but we're going to do it better than they are. And if you have that mindset, we do hard, better, it's going to work.
How much fun you having? Last question. How much fun you having doing this, man?
I mean, I love my job. I love seeing these lawyers. To be up there with Benedict Morelli, I've admired him from far. He's all the way in New York. He's probably 5'2". I'm 6'4". But as I posted on Instagram, trial lawyers come in all sizes. And he's in New York, just doing great. We're in California, but there's a lot we can learn from each other. And to have these connections, to get together with all these lawyers, and everybody here, they want to learn. They want to get better. They want to do hard better. And that's what's good, that everybody has a common goal here to share and to help everyone get better, because it benefits all of our clients.